Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill.
And I'm Sherine Abdi.
And today we're going to be talking about 5 common misconceptions about the separation process. So there's a lot, but we've decided to keep this short and simple. So we're going to talk about just 5. So one of them, and these are just random, they're in no particular order. So one thing we hear often is people ask us, are you going to serve the other side a letter? So just to give more context, usually the first step when we've met with a client and we've consulted with them is to let the other side know that we've been retained and what steps we're going to take in the matter. And so usually people think we're serving them and they get caught up in
the formalities. Like they'll ask, like, how do we have to serve it? I'm like, No, we just send it. Like we just send it either through courier, through their email.
These days it's so much easier. We could just email them the letter.
And I'm like, especially when a matter is not in court, it's not something that I think the terminology is what's confusing to them. It's we don't have to serve it. We could just send it. There's no formal process to, communicating with the other side.
Yeah. So that's an interesting one because people really get shocked. Do I have to serve it? Can I get a friend to serve? Like you don't serve it. We don't involve a process server. We just make sure that we send it. Our style at our firm is usually to send it by email and courier. The most important thing with those letters is to make sure that the other side gets it. And we're really not trying to swear affidavits and prove that the other side got that letter. If they didn't, we will try to get it to them. So don't worry too much about how the negotiation process starts. If it's a court process, then yes, we deal with service. If it's just negotiations or just reaching out to take the first step and letting the other side know, we don't do any serving.
Yeah, okay. And I think like sometimes when I get consulted by clients, they'll be like, oh, she's serving me with something or he's serving with me with something. So as a lawyer, like, I'm thinking they're court documents, but it's so often that it's just a simple letter.
Yes, that's true. So another one is when people talk about subpoenaing or that one always strikes me off.
Subpoenaing like bank records, like can we ask for disclosure? Can we get a subpoena for this? And then I'm like, no, we're not. Well, most of these, like the reason why it's a misconception is we're not even in court.
Yes.
So let's start with that because obviously there are ways to get these bank records and disclosures from the court, but that's not the process when you're not in court.
Exactly.
And I think, and there's a common like misconception, like, can we subpoena? Can we get the judge to do this? And I'm like, no, we could just simply ask. Just
honestly,
it sounds.
I can't remember what, having to even, if ever, use a subpoena process. Like you just ask, they don't provide it. You ask the judge to order it. Everyone knows with family law, disclosure is paramount. It's like the bedrock, is the foundation of everything that we have to do. Is the first step of every process. Of course, if you want to waive disclosure, then that's something that you would agree to. It has to be an informed decision. But everyone knows the importance of disclosure. So we either get it or the judge orders it or we bring a motion. But yeah, so that's an interesting one. People think that it's more than it is. They think when they've come to us that we're going to, go serve them with these like court orders asking the banks to produce this disclosure.
Or it's like an elaborated process.
Yeah, it's really not that elaborate.
Just as simple as putting, I would say pen to paper, but these days really just typing up an
fingers
email
to keyboard.
Fingers to keyboard and just typing up like, hey, I want this piece of disclosure or whatever it is that you're requesting.
Yes. So sorry to burst your bubble there. It's really not that elaborate, but to be honest, I'm glad it's not, because family law processes are already expensive and take so long as it is. So however we can simplify things, it's our firm policy. We will take, the path of least resistance. But another common misconception is people thought, I think you just mentioned this, when people are saying ask the judge for something when you're not in court. this is a huge one because people have no idea all the steps and how many months from the inception of a matter to the point where they get in front of a judge.
Yes.
And even when you're in court and you've been in court for years, you don't just go ask the judge. They're not sitting there waiting for us to give, like, for these question and answer sessions. It doesn't work that way.
No, it doesn't. Family law is very procedural. There's a step to every process. And to get, like you said, it takes months or depending on what it is, but it takes a significant amount of time before you can make certain requests. And it's not, like, I guess directly to the judge. I don't have their email. I could just say, hey, give me this, or I want this. I can communicate with court staff to set up, timelines and things like that, or bring a motion. It's, like there's so many different
very procedural.
Yeah. And especially if you're not in court, a common misconception is, okay, like, how do we ask the judge for this? And I'm like, you can't. We're not in that process. I mean, we could be, but it doesn't benefit you in this circumstance. But I think it's just such an interesting
the people have no idea how long it takes. But I think even within the court process, and this is kind of sad in the sense that people think, well, so let's say in a case where you've gone for a case conference in front of a judge. So if you're in a unified family court system, then you have that case management judge all through your process. And so say you've met this judge a couple of times and now there's a dispute. Common knowledge or just common sense, people think like we should just be able to ask that judge. And then it's very shocking when they find out that even if they go for a conference in front of that judge is only giving them a recommendation. They cannot, for the most part, they don't have the jurisdiction to make an order regarding any particular issue. You have to schedule a motion and meet the timelines and then file the affidavit and all the materials that you need to get there. And it's always very shocking to people that this is a judge. Why can't they just, order it, right? Even when they're in front of that judge. So anyway, we can't just ask a judge. Even in a conference context, it needs to be scheduled. Then we can ask their opinion and their thoughts. And then if we really want an order, we don't just ask them, like we bring a motion for it.
And this goes back to like direct communications between parties is like usually before or even during, while they've retained lawyers, I'll see, correspondences where they're threatening like, oh, the judge is going to make you do this. And the judge will say like, they will agree with me. It's just interesting to see the perspective that they have about, judicial input.
This is one that I think is really reasonable, Sherine, to be honest. Like, think about it. Like if we have a question,
make you do this, the judge is going to. Yeah, I think it's really just in the line of like the threatening nature and polarization of court, and just kind of maybe in the starting phase.
No, but let me put a scenario to you, Sherine. So let's say there's even a final order on parenting, and it's Halloween and people are not clear what to do on Halloween, and Halloween comes to mind just because it's the last holiday that's passed. So it's not like, there's nothing special about using that particular holiday. So let's say it's Halloween and people don't know what to do on that day. They're thinking, then you see the parties exchanging, like, let's ask the judge. And like, they really think. I think it's reasonable though. It's really such a fair concept. Like, this judge makes this order. I'm just going to go ask them what they meant, right? Like I can see, I really truly see the logic, but it's just unfortunate that it doesn't work that way.
I think had I not been in this field, I would totally understand that. I would probably be that person.
And it's so sad when some people come to us and it's, they're trying to resolve these issues. So let's say a Halloween conversation, for example, they're trying to hash it out. It's a week to Halloween now. It's not being settled. So we're going to go to our lawyers and now we're going to go to the judge. And it's so sad because I wish we could also get in before a judge so quickly. When you're watching TV, it almost seems like the lawyers are in court every minute. Like, we don't get that kind of airtime, unfortunately, in the GTA where we practice, right? So if you're a week away from Halloween, whatever order we're getting for you may only impact Christmas, like if we're even that lucky, because
it's just not practical. Timelines of the court and how soon you could be, even if you are in the court process already, like depending on the nature, like unless it's truly urgent, like, and I know what we can think is urgent versus what the courts deem urgent are very different things. But it's just very interesting to see like the conception of like timelines and how quickly.
Look at it.
And it makes sense. TV,
TV makes it seem like you could be there next week. Look at October, for example. We were getting motion dates for for Oshawa in February and March. Some courts, with Toronto, we could get it a little bit quicker, but definitely not in a week. We weren't getting, maybe if you're lucky, possibly a month. I'm not even, sure how if we can get that. But in some places like Brampton Court, then you weren't getting any dates for like another 6 months. So it's so we can't ask the judge in that way. So do be patient with us. We understand, but the system just is not designed. It's not as efficient as we'll think it should be, right? Okay. Another interesting one I find is this concept of abandoning the family home, and it's usually people are separated. They start out maybe living together, and it's becoming unbearable, and then they come to us and say, well, I just don't want this arrangement anymore. And I find a lot of times before they even ask, because they've struggled, they're at their wits' end, they don't want to live here anymore, but somehow they've talked to people who have told them not to abandon the home.
Yes. So
I don't know where this concept, like I really should do a Google search, because it's very common. They must be seeing this concept of abandoning the home somewhere.
Yeah, like, and I the most common way it's phrased is, okay, like, we've separated, I can't live here anymore. What happens if I leave? Can I leave? And I'm like, of course you can leave. You could always leave. And like, it doesn't abandon your claim, or it doesn't affect your claim in any way, shape, or form in terms of your entitlement to that property.
Yes.
Depending on, of course, like, different circumstances.
Yeah, but even if you're not entitled, even if you remain there, for example, it doesn't change. If your name's not entitled and you remain there after the date of separation, it doesn't necessarily, depending on the circumstances, of course, entitle you to more than the date of separation value. So it really doesn't do anything. And that also brings another concern is, like, if you're a non-titled spouse to the property, you have a right to remain there, you know, and that's also, I guess, if it's a matrimonial home,
if it's a matrimonial home, yeah.
But I think, I just find it when people ask me this question, I always look at things from a practical perspective, and just generally my practice as a whole, I just like to look at things practically. You're not abandoning your claim, but what the issue might be for me, what I'm looking at is, okay, if you leave this home, are you able to afford the other home? Because some people, especially in longer marriages, you might have a home that's mortgage free. And if support is not in place, and I can't get, to a judge soon enough to get you support, by leaving that home, you've increased your expenses, but not necessarily your income. So it's practical things like that we're concerned about.
Or strategic, to be honest. Sometimes if I know that, you leaving the home while you're still paying for it doesn't really entitle the other, or doesn't really get the other party moving in terms of settlement-focused ideas of how to deal with the division of the property after the fact, then I'm less inclined to advise you to leave. Yeah. Obviously, it depends on the circumstances, but
exactly. Do not put yourself in a dangerous situation is what we're saying. But there's times where it makes sense to remain there. Sometimes it's practical, but none of that has to do with you abandoning the home. It's not even abandoning the claim. The way it's usually phrased to me, it's almost as though they're committing a crime of abandonment of the home. And no, there's no such thing. And the last one we want to talk about, and as we said, we have a lot. So maybe another day we'll talk about some more, but we just picked this 5 randomly. One is, the last one is the significance of cheating. This one breaks my heart.
Me too.
It does, because people, I get it. It's morally, it's wrong. It should not happen. Homes should not be broken this way. People, if you make a vow, you should keep it. Even if you don't make a vow and there's an expectation of monogamy, like, don't break it. I get the dishonesty. I get it all. It's a mess. I understand. But by the time we get to dealing with the legals of it, it means absolutely nothing.
I think the common misconception is it entitles you to, different things, or the non-cheating spouse is entitled to other assets or whatever it may be.
I feel like in some places in the States, it might be a thing. And again, this is just from TV. Like, I do not know.
This is from TV that I agree with you that it seems to be that way. If there's committed adultery, or, there's some things that, like, you would have to, that would affect your division of property or your assets.
And people come to us, and I think the ones that hurt, like, I feel worse for, are people that want, when they come to us, they want to make sure they've done their homework. So they've hired the private investigators. They've
spent months, years,
yes,
like collating receipts, proof, and I think to them it's like, it's not just, okay, you know, the person's cheated on me. It's, I have years or months of evidence and I can substantiate everything I'm saying. It just unfortunately doesn't mean anything in the context that you guys would deal with. Like, ultimately, obviously from a moral perspective, I understand.
And speaking of morals, I've also had a client be surprised that parenting time would be given to someone that has cheated. Because they're saying, well, this is a person of low moral standards. Is this really the kind of dishonest person that we want to be raising this child?
Oh, that's interesting.
And yes, and it's I understand what they're saying. I hear them and I understand, but it just really doesn't work that way. And I try to explain that someone can be a bad husband and still be a good father. They might be, you know, yes, cheating is, we disagree with it in all forms, but it doesn't necessarily translate to them being bad parents, right? Yeah. I mean, again, if we want to really take this to its logical end, if we're going to say, well, you lied about, you know, our relationship by cheating and you broke my trust and all that, well, how about when people lie about being on the phone when they're not? Like, you know what I mean? Like, if we want to take honesty to its logical end, well, a lot of people would easily tell a child, well, tell them I'm not home. And, you know, back in the days when we had landlines, now that's not even a thing anymore. But you know what I mean? Like, where do you draw the line between white lies making somebody a good parent versus a bad parent? So it's, much as we sympathize with the sentiment and we understand where it's coming from, it's just so sad that when we have to share the news that it does not.
Yeah, I think sometimes like anything. It hurts so much when I see, like, this is the starting point of maybe a consult, and I'm not interrupting because I want to hear the background, and it seems to be like largely stemmed on the fact that the other person, you know, has cheated on the person, and I hate to interrupt just to be like, you know,
it doesn't matter.
Because to them it matters, to the sense that that's why they're here and they're consulting with me, but it's still, I already know where it's going, and I hate that I even have to break that news.
I know.
But and to touch on another point, it's not necessarily cheating, but I think another common thing is if someone leaves the relationship,
yes,
even though, you know, maybe you'd never found out they cheated, or they just never cheated, because it was their decision to leave. There's another misconception that, oh, then they're not entitled to anything because it's their decision. They're not, you know, they're leaving.
Some
they're not
think
entitled.
They should even get to keep the matrimonial home, for example, because I didn't ask for this. I didn't ask to leave the relationship.
Or like they're definitely not entitled to spousal support because they've made the decision to leave. That's a very big common one. And unfortunately, that's not the case.
Yeah. So, well, sounds like we've gone from like 5 to 8 and we could keep going, but no, we said 5 and we're going to stop there. So things aren't, I mean, that's why we always encourage people to consult with a lawyer as early on as possible in the process. You know, if your partner has cheated, talk to a lawyer first before you invest all of the time and additional resources trying to prove something that really would have no bearing on your case. You know, in terms of getting records, things like that, just trust us. We know what we're doing. We've helped a lot of families, and, you know, we like to feel like we're helping make family lives better. And we know that at the point where we're working with you, it doesn't necessarily feel that way, but we have your back is what we're saying. Okay?
Absolutely.
All right. Until next time. Bye for now.
Bye.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.